Is this a good time to apply for naturalization to become a U.S. citizen? Hi friends, I'm immigration attorney Christian Alvarez, and today I'm going to talk to you a little bit about naturalization process and whether or not it may be a good idea for you to apply. When someone talks to me about applying for citizenship, the first thing I ask is, tell me a little bit about your immigration history. How did you obtain your lawful permanent resident status or your green card? And how old were you? Where did you interview? Who petitioned for you? I want to know all of that. And the reason is really twofold. First of all, I want to make sure that the person who is going to be applying for citizenship doesn't have any issues that can be discovered right at the interview that can hurt them. So how can that happen? Sometimes immigration grants green cards or grants lawful permanent resident status based on a mistake. Maybe the person was a child of somebody who immigrated along with them, and perhaps the parent also may have committed some sort of fraud or some misrepresentation. Perhaps they never qualified. So there's a plethora of reasons why maybe the green card was issued in error. The naturalization stage is the last stage in which an officer really takes a look at how the person became a green card holder, and if there was ever some sort of error in the granting of that initial green card, even if it was like 10, 15, 20 years ago, the officer can not only deny the citizenship, but can serve the person with a document called notice to appear. Now, the notice to appear, otherwise known by immigration attorneys as this NTA document, is basically a document saying you got to go to court. We believe you're removable. Now, a person who's removable is a person who may be deported back to their home country or another country that can accept them. And lately in the news, we are seeing individuals who are being deported not just to their home country, but to other countries that have special agreements with the United States that is willing to take deportees from other nations. So very important. I want to know, how did you get your green card? Did you really qualify? Was there any irregularity there? The second reason why I ask about the immigration history is because I want to know if perhaps maybe this person is already a U.S. citizen. There are a lot of people who immigrate because their parents are U.S. citizens and their parents sponsor them. And sometimes children are already U.S. citizens at birth. Even if they were born in another country. Sometimes they're not citizens at birth, but the moment they touch U.S. territory with an immigrant visa or green card status, they become U.S. citizens. Sometimes they enter the U.S., they're not U.S. citizens, but their children, they're minors under 18, and a parent, father or mother, naturalizes in a year or two or whatever. When they naturalize, if the child is still under 18, the child may have also derived citizenship status. So there are many ways in which we need to make sure you may already be a citizen, or we need to make sure that you're not already a citizen. Because what happens if immigration determines, hey, you're already a citizen, you derived it from your mom or dad? Well, you apply for naturalization and that process is going to be denied. So they're going to tell you, just go straight to the passport office or apply for a certificate of citizenship. The form you filed, the N400, is inappropriate for you because you are already a citizen. You do not need to go through the naturalization process. The second thing I ask people is, what country are you from, and does that country allow for dual citizenship? There are some people from China, India, Japan. A couple of countries don't allow dual citizenship. And are you okay with losing your country's citizenship in order to obtain U.S. citizenship? Most people who talk to me about naturalization, they kind of already know the rules, so they're usually okay with that. The third question I ask is, tell me a little bit about your criminal history anywhere in the world. Have you ever been arrested? Have you ever been detained, cited? Any DUIs? Sometimes people tend to think that if the arrest is very old or the case was already dismissed or you paid an attorney to expunge this record, that perhaps everything's okay and you can mark no on the question about arrests. So just so you know, And in the immigration world, there's no such thing as a erased record or too old of a record or an expunged record. Any arrest you ever had in your life, even if it was a small little detained period where the case was dismissed or you were simply let go, everything needs to be disclosed and everything needs to be papered. Just because you were arrested or you had a conviction, it doesn't necessarily mean that you don't qualify for naturalization. There are a lot of people with criminal convictions who still qualify for naturalization. There's two rules that we really want to look at. One, have you committed 2 or more crimes of moral turpitude? Why do I want to know about crimes considered moral turpitude? Because if a permanent resident commits 1 crime of moral turpitude within the first 5 years of becoming a permanent resident, they may become deportable. So if you have committed 1 crime within 5 years, maybe applying for citizenship is a little risky for you. If you've committed 2 crimes that are considered or labeled as crimes of moral turpitude, anytime in your lifetime as a permanent resident, that can also make you removable. So sometimes applying for citizenship can be very dangerous if you have a criminal history that can send you to immigration court because you are already removable. Now, technically, there's a 5-year look-back period for another evaluation that an immigration officer does. Is not just are you removable, but do you have good moral character? The good moral character period is 5 years from the time you apply, or 3 years if you're applying under the 3-year provision. Who can apply for the 3-year provision is individuals who are married to U.S. citizens. But everybody else has to wait 5 years from the time they become a permanent resident to the time they can naturalize. You can apply for naturalization 3 months or 90 days before that 5th year anniversary or the 3rd year anniversary. So as an attorney, I always ask about my clients' arrests. I want to make sure, do we have any problems with a good moral character element, or do we have any problems with removability? Can applying for citizenship land you in immigration court? And just so you know, a little anecdote, I had a client who luckily we were able to win their case in removal proceedings. But this individual, because they spoke English, they had been a permanent resident for a long time, they thought, oh, I can go ahead and prepare my application on my own and submit it, and I should become a citizen. Well, immigration took a look at his arrest history and they decided to send him to removal proceedings. Not only did they deny the citizenship application, but they sent him to immigration court because based on the arrest history, they were arguing that he had more than 2 crimes of moral turpitude. Therefore, he was removable. It took about 11 years to get that case cleared up. So be very careful before you start to just submit these applications on your own. I know that there are a lot of nonprofits and a lot of organizations that can probably fill out the form for you, but the question is not about the form. The form itself is just, your information and your name and your address, your work history, but it is more about, do you qualify? Or even if you don't qualify, can this put you at risk of being sent to removal proceedings? Now, what happens if you get sent to removal proceedings and then you don't win your case there? You get a removal order or a deportation order, and you run the risk of course, being deported back to your country. Another question I ask is, do you owe any taxes, overdue taxes? Do you owe any child support? Child support and taxes are a big deal for immigration. To them, it's part of whether or not you're a person of good moral character. Now, there are people who are disabled or earn so little. Maybe they went through a period of unemployment and they earned so little that they never even filed a tax return for a specific year. If someone didn't file tax returns for a year because they didn't work, or they were perhaps disabled or on some sort of non-taxable reason, that's probably okay for naturalization purposes. But if you did work and you just simply chose not to file your taxes, that can be a problem, and you should definitely bring this up to an attorney who's evaluating your case. Another question I ask is about travel history. There are people who don't stay here the whole year and they tend to travel a lot. Now, if you're one of those people that travels a lot, just so you know, whether it's a 3-year look back period or whether you're doing your citizenship for the 3 years or 5 years, Immigration requires that you were physically present at least 51% of the time in the last 3 or 5 years. So now remember, there are people who apply for citizenship because even though they've had their green card only 3 years, they're married to a U.S. citizen, so they can apply a little bit sooner than people that apply through the regular 5-year provision. So I ask about people's travel history because I want to count the days that they were out of the country. If they spent too much time or more than 51% of the time, then they may not qualify. We may have to wait a little bit longer to apply. So sometimes it gets nitty gritty for people that travel a lot. We have to really count the days. Some people are like, oh, I take 2-3 vacations a year and they're no more than a week long or 10 days. And that's fine, no problem. Let me see what else we have. I think that's usually it. Now, what questions are usually asked in the citizenship application? The officer, depending on your age, depending on how long you've had your green card, the officer may require that you speak English, that you read and write, that you can read and write in English, and that you know the civics questions. Now, the USCIS website does publish a list of 100 civics questions that you need to memorize, and from there, the officer will ask up to 10. Usually, if you get the first 6 right, you're considered to have passed, and then they will stop the test right then and there. Now, depending on your age, depending on how long you've had your green card, you may be able to qualify to do this application in your native language with an interpreter. Maybe you don't need to learn the civics questions, or maybe you just need to learn a reduced amount of questions. There are people who may also qualify for a medical waiver if they have some sort of disability that impairs their learning. That may also qualify them to do the application without having to show either language skills or the civics questions. But all of this, friends, is something very detailed that you definitely need to run through an experienced immigration attorney so that they can give you a thorough evaluation of your specific case. And friends, we have 2 offices. We're located in New York City and in McAllen, Texas. If you're interested in my office evaluating your qualification for naturalization, feel free to visit us at alvarezimmigration.com. We publish a calendar with open appointments for first-time clients, and we'd be happy to evaluate your case. Thank you, and see you next time.